Well, good afternoon, good morning, good evening. I hope everybody's doing well. It's been a little bit, and so I took a little break. I am taking a little break here from the morning. The oh, okay. Let's start over. Just got completely brain shut down. Good morning, good afternoon. I hope you all are doing well. Yes, I've taken a little bit of a step back from the morning mystery theater and the lunch break live. What I'm going to be doing is putting them into like video format so then we can do them as a premiere versus a straight live stream. That way, all the information what you see on screen will be more of a video. So I can sit back and relax with y'all in the chat and not have to be monitoring the back end. And that also will give me the ability to schedule them. So if for some reason I'm not around, they'll automatically load and be pushed out to the platform, whether it be YouTube. And I think I can also do that with Kick as long as I am using OBS. So look forward to that. Keep your eyes peeled for that. But today, what I want to touch on is all the deep dives within the various neighborhoods within the trauma community. A lot of it is been deep diving past live streams of either Julie's or Brittany's, and I want to upfront, 100% upfront. We'll nip any BS in the bud right now. This is not in a response to any creator, nor is it a response to any particular chatter or audience member. This is not in favor of or against any creator or the people involved in the recent round of complaints and litigation. This is going to be a slight side quest and my 2 cents, my opinion as a reasonable person, as a learned individual that has spent 30 years in this arena. And so let's nip that in the bud right now because I have seen a lot of scuttlebutt going chat to chat to chat, how people's perception or interpretation of what's being discussed on screen is somehow pertinent to a particular creator, and things are taken out of context and they've been blown out of proportion. So let's nip that in the bud right now because I don't want to see 3 hours from now an email stating, well, hey, I heard you just had this live and you're calling out so and so. I'm not calling out anybody. You all know how I do things here. I do a presentation. If there's legal case law that applies, we'll discuss it. I'll bring it up and y'all can look at it for yourselves when you have time. I also will insert my opinions, and where things are just my opinion or from my point of view, I put that up there as in quotations. You know, when you write and you're speaking in first person on a piece of paper, what you're saying is in quotes. And I've been following that format. So for the most part, people understand that if a particular slide is strictly my opinion or my words, it's the delineation is there. It's denoted that way. So without any further ado, I'm going to go ahead and dive into this. And it's going to be a quick one because I understand that there's a few people live and I share audience with a lot larger creators. So when you're here on the replay, please say hello in the comments. I appreciate it. and it's good for engagement, and it keeps the community growing. So here we go. Could your YouTube comments land you in court? And let's go ahead and, oh, oops, wrong. Don't want to do that. I think, there we go. Hide the camera. Okay, one moment. Apologize. Trying to keep the cats down to a minimum so they don't interrupt as often as they do. I've had some feedback that it's can be quite annoying. It's not cute or fun. So I do apologize for that, but they are cats and they have a mind of their own. Okay, Law and Order, guilty, not guilty. As you can see, the graphic here is just kind of a cutesy little representation of what we kind of see online. So imagine you're in a courtroom. The case isn't just being discussed by the jury in the box, but by the jury in the YouTube comment section. Can a judge actually use a live stream or a subreddit to decide what a reasonable person would think? It's a wild new frontier in law, and today we're going to break down how the internet is literally changing the rules of the game. First, a quick law school hack. The reasonable person. It's this imaginary, perfect human the law uses to judge us. But here's the catch. Courts usually treat this person as a legal fiction. They aren't supposed to be a Twitter mob or a hyped up Discord server. Why? Because online communities can be, well, a little biased, but that's starting to change. And it really is starting to change. For example, take the Johnny Depp and Amber Heard trial. This was essentially the world's first truly social media trial. Even though the jury was told to stay off TikTok, the online vitriol was so loud it created a popularity contest atmosphere. Amber Heard's team even argued that the digital storm made it impossible for a truly reasonable juror to stay neutral. It showed us that when the internet picks a side, the reasonable middle ground starts to disappear. But the Supreme Court has pushed back. In a case called Alonis versus the United States, a guy posted some pretty dark, violent rap lyrics on Facebook. The government said, hey, a reasonable person would find these threatening. But the Supreme Court stepped in and said, not so fast. They ruled that you can't just use community outrage to convict someone. You have to prove what was actually in the person's head. Basically, the internet's feelings aren't a shortcut to a guilty verdict. And this is going to work both ways, and I'll touch on that as we go forward. There's also a huge risk called the Heckler's Internet Veto. This is the idea that if we let online comments decide what's reasonable, then the loudest, angriest people on the web get to set the laws for the rest of us. Judges are terrified of letting a niche community, no matter how big their live stream is, dictate what is normal behavior. But again, this is also changing because how a community responds to each other can be used in a defense or by the prosecution to indicate what's reasonable within this peer group. Okay. And I think that's where we're starting to see lines really blur with the deep dives that are going on. And so hopefully I can try to clear up a few things while also doing my very best to stay neutral and keeping it basically black and white, and try to pull us out of the gray area a little bit, because again, comments like, well, this is benefiting one side or the other. That's not necessarily the case, and hopefully I'll be able to pull out that nuance for you today, and you'll be able to see. So one more moment. Okay. All right. However, we are seeing a shift in cases against big tech companies. Jurors are now looking at millions of user reactions and online feelings to decide if companies like Meta or YouTube are negligent. In these cases, the online community isn't just noise, it's evidence. And this is incredibly recent that an individual was able to sue Meta and Alphabet, not as the platform, as the host, which is how they enjoy their Section 230 protections, but the lawsuit was based on the algorithm. And we will touch on that. And that was just decided on the 26th of March of this year, 2026. And the companies do anticipate appealing the ruling because it was, I believe, $7 million to the litigants. That's what they were awarded in damages because of the distress, but we'll get there. So the next time you're typing in a live chat during a trial or at any time, remember, you might be contributing to a new version of community standards that could end up in a legal brief one day. And that's never more evident than the case that the injunction RICO that was filed against Barbecue and Granny. So everything that has been in those filings, from the original complaint to everything afterwards, is going to be part of the legal record. And what that means is, at any point in time in the future, a future law student will open up a book and will read about this case. And everything that's been said online, that has been entered into the record, will be there. Your name, your avatar, your screen name, your comments. And this is where the analog and digital binary is shifting. We always want to be aware of what we're saying because it could come back and bite us in the butt, but never more than today, because we are in a more digitized environment. And when they say the internet is forever, as long as there's electricity or a way to power that screen, that's true. I think it's true. So here we go. A reasonable person versus an online community. The use of online community commentary and live stream reactions to demonstrate a reasonable person standard is an emerging and complex area of law. While courts are increasingly comfortable with social media as evidence of facts like a litigant's location or their state of mind, excuse me, using a digital mob or specific online community to define the reasonable person benchmark remains legally contentious. In legal terms, the reasonable person is an objective, hypothetical ideal, a legal fiction, rather than a collection of real people's opinions. The objective standard, courts typically resist using specific groups, like a YouTube chat or a subreddit, to define reasonableness, because those communities may be biased, radicalized, or non-representative of the general public. The community standard. One notable exception to this is in obscenity law, where the Supreme Court's Miller test explicitly requires a jury to apply contemporary community standards. In such cases, online sentiment might be argued as evidence of what a modern community finds acceptable or offensive. And that's never more true with terms like dumbass, um, the use of bitch, son of a bitch, and even whore or slut. And while those are terms that are derogatory and they import some type of slur against a woman's chastity, her moral behaviors, in the context of certain communities, it's modern parlance. That's how we speak. Hey, bitches, what's up? You know, hey, whore, where you been? You know, and again, this is where that real world versus online realm are colliding with how we speak, how language is used, and where this is going to fit in. Because not all, excuse me, the foundation of the judiciary, of our legal system, our laws, our acts, our statutes were originally based in real world offline experiences where people did know what was expected of them and what a boundary was, what personal space is, um, having decorum, an inside voice, home training, if you will. That's blurred, not just because of the internet per se, but because of social media and the immediacy, the constant 24/7 in your face ability to connect, to comment, to troll, and to receive that feedback. So we are entering new realm. It is a new realm. And working that out so it benefits the whole and not just one person, while still maintaining our standards in this, contemporaneously with um, how people behave online. Now, does that mean we should censor ourselves? Not necessarily, but it does go to show that how we view the way we use certain words has changed, and it's continuing to evolve. Again, what may be a threat to one person is simply somebody on the other end just being a jackass. So while the line is blurring, we still need to remember that we are individuals, not just an avatar on the screen. So let's continue on. I'm sorry, I'm side questing. The virtual presence and perception. Recent rulings have allowed live streams to satisfy virtual presence requirements. For example, a California court ruled that parents watching a live stream of their child being abused could sue for emotional distress, treating their virtual experience as equivalent to being there in person. This suggests that how a person feels through a screen is becoming legally recognized. And that's what I was trying to get at just a moment ago. Admissibility. If a lawyer attempts to introduce live stream comments or community reactions to show how a reasonable person would feel, they must overcome several evidentiary barriers. The first and foremost being hearsay. Comments made by third parties online are generally considered out-of-court statements to be used as proof of what people felt, they must often fall under an exception, such as a present sense impression or state of mind. The authentication. The court must be convinced that the comments are authentic and not the work of bots, trolls, or coordinated brigading. We all know what that's like. We've seen it for years in various communities. And the prejudice, which is Rule 403. A judge may exclude online commentary if its probative, if its probative value, helpfulness in proving the point, is outweighed by the risk of an unfair prejudice, meaning it's the good that it could do is not outweighed by the substantial bad that it would provide or show. Like somebody to be, which we often hear about when we watch cases online in trials, is prior bad acts, or perhaps a specific criminal record, or how someone treated previous girlfriends. Sometimes it's allowed and sometimes it's not, and it's weighed on this Rule 403. And here we go. Commentary that is inflammatory or represents an extreme niche may be deemed too biased to represent a reasonable person. In each of the slides, there are going to be reference materials or source links on them. And as always, I will be providing further reading or sources for you at the end of the presentation. How does this work? Strategic uses in court. Impeachment. Commentary is most frequently used to challenge a litigant's credibility. For instance, if they claim to be devastated but are seen joking with followers on a live stream. And this is important because we've heard that, well, how can somebody be in fear or upset when they're joking or they're doing parodies? And I'm going to touch on that briefly because it is relevant from not only a legal standpoint but from a psychological standpoint as well. And I will be providing references regarding that for you all today too to look at. Now, does that particularly prove the individual that's turning what's supposed to be a frightening situation into a clown show? Does that prove that they're not afraid or not scared or not concerned? Not necessarily. So we will get into that, and which again is why when we talk about the big picture and putting all the pieces of the puzzle together, it's not just what's in front of our face. And that little bit of nuance, or what some think may be nuance, actually has a foundation, not only in law, but in psychology. So, public perception in high-profile cases. In rare instances, widespread online reaction might be used in motions for a change of venue, arguing that the local community's reasonable person has been so influenced by online talk that an impartial jury is impossible. One moment. I apologize for the breaks, you guys. I do apologize. I'm working really hard to speed up my speech, while still being y'all being able to understand me, because I do have a speech impediment, and if that hasn't been made evident over the last 2 years, just through listening to me. Okay. And this was never more evident in the Johnny Depp versus Amber Heard trial. The defamation suit between Johnny Depp and Amber Heard is the most prominent example of online sentiment potentially bleeding into a courtroom. The context: the trial was live streamed, leading to a massive surge in TikTok memes, YouTube or LawTube commentary, and hashtags. For example, justice for Johnny Depp. The legal issue. Thank you to Jennifer. I really appreciate it. That means a lot to me. It really does. The legal issue. While the jury was instructed not to look at social media, Heard's legal team argued after the verdict that the unprecedented online vitriol against her made it impossible for a reasonable juror to remain impartial. And the result, the case highlighted a the popularity contest effect, where the massive digital support for one side may have influenced the perceived reasonableness of their claims in the eyes of the public and potentially the jury. And this is the little bit of nuance with the deep diving. And again, it's not just in the trauma community. I'm talking, this is widespread in any community. You can go to any community where drama unfolds and find deep dives and receipts. And that's going to come up in a little bit as well. Some more cases for you. The Alonis versus the United States, the subjective versus objective standard. The Supreme Court case centered on a man who posted violent rap lyrics and threats towards his ex-wife and law enforcement on Facebook. The issue at hand was the lower courts used a reasonable person standard, arguing that a reasonable person would view the post as a threat, and it was a crime. The ruling. The Supreme Court overturned this, ruling that for a criminal conviction, the government must prove the defendant's actual intent, meaning the state of mind of the subject. And this is the subjectiveness of anything, especially in civil cases, where it's something that's coming from the internet into your real life. Not just what a reasonable person reading a Facebook post might think or feel. This limited the ability to use community outrage online to define criminal liability. But civilly, this is changing. The line is no longer being blurred. We're crossing into a whole new area of law that is growing and developing. So in a lot of these, not a lot, in some of what we're seeing in our own communities online, the law is going to be an outgrowth of these online disputes going forward. And we're all here for it. All I can say is don't get your name on the piece of paper, because what's been done to Granny is it's just awful, and to Barbecue. It's just it is. I do fully believe my opinion and belief is it is lawfare. It is the definition of lawfare, and to watch all the proceedings and filings play out the way they have, it's been an end run around First Amendment protections and to financially bankrupt and try to emotionally destroy two other human beings. It's vile. It's foul. It's disgusting. Yeah, but that's for another day. And here from the Commonwealth of Pennsylvania versus Chandler. This was from 2020. Live streams as trauma. In a murder trial in Philadelphia, the killing of Marquise Chandler was captured on video and shown during a live-streamed court proceeding. The result? The district attorney successfully argued against future live streaming of criminal cases because the online dissemination and potential for witness harassment created an incalculable trauma that overrode the public's right to view the proceedings. This case shows courts recognizing that online feelings can be a valid reason to restrict traditional transparency. And redistrict might also be, even though that was a slip of the tongue there for me, but redistrict. When we redistrict something, it means we move we move goalposts. You know, so that's where we're at. Things are changing, and they're changing rapidly. March 26, 2026, the landmark case. Facebook, Instagram, Google, and YouTube. As of March 2026, a landmark verdict in Los Angeles against Meta and YouTube have found these platforms liable for negligence in their design. Jurors ruled that Meta and YouTube were negligent in designing and operating their platform, factors that resulted in harm to the plaintiff. The jurors also found that the companies were aware that their platform could have adverse effect on minors, but failed to adequately warn its users. This is a shift. In these trials, juries are increasingly looking at internal metrics and user reactions, essentially the online feelings of millions of teens. And this would also go into adults, not just young people, to decide if a reasonable company should have known their product was harmful. Social media companies have long deflected such accusations by taking legal refuge behind Section 230, a clause in the 1996 Communications Decency Act that protects internet companies from liability for third party content posted on their platform. The case, however, centered around how the apps are designed, not the content itself. Ashcroft versus the ACLU, the Heckler's Internet Veto. Justice Stephen Breyer raised a critical concern regarding community standards on the Internet. Excuse me. The concept. He cautioned that if the law allowed the most Puritan of communities online to set the standard for everyone else, it would create a Heckler's Internet Veto. The impact. This remains the primary reason courts are hesitant to let a specific online group, like a subreddit or a live stream chat, define what is reasonable. It would allow the most vocal or extreme online community to dictate legal standards for the entire country. That being said, this is my viewpoint coming in now, not the Chief Justice's. These lines are being blurred, because if the issue is between two online personalities within the share audience within the same online community, there is a community standard. Granted, Karama, that standard, I don't know when it went out the window, but it is rage baity, it's troll baity, FOIA requests on other creators, police reports bandied about for content, um, text messages leaked, private conversations turned into content farming. Um, so, again, is there a standard within Krama? Or is it the Wild West? Or is it, pardon my French, the I don't give a fuck community? Seriously, think about it. You know, do you want courts or laws to be changed, modified, or adjusted, or put into place based on the standards of this particular community? I don't, because this community is invasive. And that's my opinion. Not the entire community, okay, before panties get all twisted and emails start flying, okay? Not the entire community. Not every participant, every creator participates or engages in that. But let's be honest with ourselves. As I said several months ago, look in the mirror. What are you allowing within your own little corner, your neighborhood? of the wider community that you're in. You know, so and again, if I'm coming off pissy, I'm it's just where I'm at right now. It's I disappointed. It's not even disappointment. Is it disillusioned? Is it or just coming to terms with the fact that yeah, there's shitty people out here, and the more you entertain shitty people, the shittier they're going to be. And again, apologize for the language, but um, I'm that I'm that enthusiastic at the moment that sometimes adult language comes out just to make a point. So let's compare and contrast. A prosecution's view, which is an isolated view, aggressive language focuses on specific timestamps where the defendant used loud or forceful words. A contextual view, which is a community defense, is community slang or banter. Proves the language is a common, non-threatening inside joke or established community persona, or how somebody behaves online, which the shock jocks type of thing. Um, and now, with saying that, does that mean that we completely turn a blind eye to somebody that's a nasty piece of work? Well, again, that's where personal responsibility comes in and accountability. You don't have to watch. You don't have to participate. You can observe from the sidelines, but not engage. And I'm a big proponent of that. Just don't engage. Just, but then again, nobody's anybody's boss. So, again, you see that this is just, and I think this is why we do get so emotionally charged in the chat. There's because of live streaming, that parasocial boundary it has thinned because there is immediate interaction with the creator or with the channel host and the chatters. So we get caught up in that feedback, in whether it's positive or negative. And we may type things in a chat that we wouldn't necessarily say out loud or in a public space, but because it's online and we're in the vibe, it gets blurted out, whether on stream, on panel, or in the chat. So again, that's just like, are we living in the digital world now? And do we want the digital world to be a completely unrestricted, no holds bar chat room? I don't know about you, but I don't. And the repeated contact shows 15 messages sent in a short burst to prove an intent to annoy or alarm. Real-time interaction shows the accuser was actively responding, laughing, or tagging the defendant back during the same outbursts. Again, contextual views. Excuse me. Unprovoked outbursts presents a 30-second clip of a heated argument stripped of what happened before. The contextual view, which might be a community defense, is a reactive conduct. Uses the full 4-hour stream to show the defendant was responding to a specific provocation or trolling from the other party. Evidence of intent, a single screenshot of a threatening comment, a digital fingerprint, the metadata. Uses full headers and logs to show the comment was edited, taken out of a sarcastic thread, or sent by a different user. These are all things that are now coming into play in the courtroom. So we're going to keep those in mind. Okay, one more moment while I pull up the next. Oops, I accidentally muted. I'm sorry. Okay, coping through parody. Why victims use parody to cope. Restoring control. When confronted with threatening, irrational behavior, creating parodies or mocking a perpetrator can shift the victim from a passive target to an active participant, mitigating feelings of helplessness. Diffusing power. By turning a threat into something ridiculous or absurd, the victim can lower their fear level and make the intimidating behavior feel less significant. Reclaiming a public identity. Victims of stalking or constant harassment may use creative outlets such as satirical accounts or parodies to combat the false narrative a perpetrator is trying to create, thereby reclaiming their image. Dark humor as therapy. Making light of severe situations can help process traumatic experiences and regulate stressful emotions. And this information is gathered from psychcentral.com. Contextual considerations. Self-enhancing versus aggressive humor. Research indicates that research indicates that self-enhancing humor, finding humor in a situation to support oneself, is an adaptive coping strategy, while aggressive humor, hostile or abusive, can potentially escalate the situation. The risk of escalation. While this is a common coping mechanism, it is important to note that responding to threats with sarcasm or parody can sometimes cause the harasser to become more determined or obsessed, escalating the situation. Abnormal reaction to an abnormal event. This behavior is considered a normal adaptive response for a person dealing with an abnormal, traumatic, or frightening event. This is from semanticscholar.org. These links are provided here for you. I'll also provide them in the description once the video is over. It's something to read into, and I had attempted to make a comment in a chat, and I honestly don't recall whose chat it was in, and then it was like, why bother? Because we're not just dealing with the deep dive, because we start getting into human behavior, sociology, psychology, and those are side quests of their own. But it's important in the aspect of what we see in the trauma community. It's important we see this in, well, whole communities have been made around it. You know, we've got the LCU, we've got Girl World. Also, there's, again, wherever there's going to be drama, we're going to run into these issues, because what's one person's commentary is another person's feeling slighted. So I do think that in the context of the deep dives in trauma, and parody is a portion of trauma, we do have that satire that comes out, whether it's through song or video or the animation or the trauma babies even. I think it's important to this conversation that we're having, to just include this as part of the nuance in the bigger picture. And some important key points: subjective versus objective. Harassment often requires the conduct to be both subjectively offensive to the victim and objectively offensive to a reasonable person. Online communities are now acting as a shadow jury to define objective standards. The contextual defense. In states like Texas, a key defense against online threat charges is showing the full conversation, not just the prosecution's excerpts. Community receipts can provide this necessary context to disprove harassment. Conversely, these same deep dives may provide the necessary documentation that shows a pattern of behavior or course of conduct meant to intimidate or alarm the intended recipient or others within the same community environment. So again, these deep dives and these receipts, they literally can go both ways. The authentication hurdles. Even if a community proves someone is a harasser, that evidence must be authenticated in court, proving who actually sent the messages or made the comment before it can be used to sway a judge. And here are my final thoughts. Now, here's why it really matters in the real world. Let's say a community member is accused of harassment through a citizen's complaint. In these cases, the defense almost always hinges on one question. Was the behavior actually harassing to a reasonable person, or was the accuser just being overly sensitive? And this follows up from my 2 previous live streams regarding the laws for this particular situation. This is where crowdsourced investigations come in. When an online community picks apart hours of live streams, analyzing every facial twitch, every joke, every interaction, they aren't just gossiping, they are essentially building a digital case for reasonableness. For the accuser, the community might find a pattern of microaggressions or dog whistles hidden in the streams that a judge might miss. They provide the context to show that to a reasonable person in that specific community, this conduct was clearly meant to intimidate. For the defense, conversely, the community might receipt the accuser showing they were actually participating in the banter, or the harassment itself was actually common community trolling. This can be used to argue that no reasonable person could have felt truly threatened in this environment. The danger is what legal experts call context collapse. When an outside judge or jury looks at a 30-second clip stripped from a 4-hour live stream, they aren't seeing the reasonable standards of that community. They're seeing a distorted version of reality. And with that, also, when you rely just on one source for deep diving, you're getting that through the eyes of the streamer. If you don't know any of the participants, if you don't, we don't know any players in this game, but we walk into a live stream and we've got commentary going about, this character or that character. Subconsciously, we are forming an opinion, not just of who's giving the commentary, but of the people that they're discussing. So we are subject potentially to the bias of the streamer. So let's be aware of that too. When we're out here participating on the internet, we might be getting influenced in ways we hadn't thought because it's so subtle. It's incredibly subtle. Okay, let me go back over. The danger is what legal experts call context collapse when an outside judge or jury looks at a 30-second clip stripped from a 4-hour live stream. But in a world of citizen complaints, your reasonable person defense isn't just about what you did. It's about how the internet's digital forensic team interprets it. Why it matters is simple. Your online reputation may become your literal legal reality. As more of our lives happen in 24/7 streams, the legal system is being forced to catch up to the reality that a community isn't just a physical neighborhood anymore. It's a digital one with its own unique rules and reasonable behaviors. So this has been my 2 cents. I hope you found some value in it. I hope it's also cleared up some of the questions that I've personally been asked and touched on some of the things I've seen out and about in the chats and through the streams. Some helpful hints: the digital receipt checklist, how to protect yourself, context captures. Never just screenshot a comment, save the entire thread to show the tone and flow of the conversation. Interaction logs. Keep records of an accuser's active participation. If they were laughing or hearting comments in the same stream, it rebuts the claim of unwanted harassment. Community norms proof. Document other similar interactions with that specific community to show that your conduct was typical and accepted behavior for that group. While this is helpful, it's not foolproof, you guys. Be aware that everything you type can potentially be used as evidence to exonerate or impeach in your online community or your local courthouse. You can screen capture this. There's some links there for you if you want some further information. And again, this isn't in particular to one streamer, one community, or one person. I've gone through my comments. I've gone through emails. I've also watched chats. I've watched streams, and I've seen certain questions come up, and I just want to provide my point of view, apply the law where it's necessary, and give you my opinion, my 2 cents, as I said. And all right, I will see you out there, and have a great day.